All right. Hello. Um, Welcome back to the Huntsville State Planning Lawyer criminal chat. So today, just hot off the press, right before I came on here, the news is that Sam Bankman-Fried has been found guilty in his fraud trial, where he has now been convicted of um, embezzling, fraud, deceit, and I had to go back and look at all those things. But he has been found guilty after less than 5 hours of deliberation by the jury, and it was like an $8 billion fraud trial. So that was that's pretty big, and it may not have affected you and me, but there were people that were affected by it. And anytime there is fraud in a um, scheme that can make its way down to people, to you and me, that's a problem. So I haven't followed that one as closely, but it is just because it's a white collar crime doesn't mean it's a victimless crime. It just means it has to do more with high dollar amounts and some fraud, some security exchange, some securities issues, just so much on that end. So that's just happened right before I came on live, that he was found guilty. So, um, so I want to mention that, but then tonight we're actually going to be talking about a couple of cases. One, we're going to go to the Murdaugh trial. So there have been some developments in the Alex Murdaugh trial where he has asked for the judge to be removed from the case. So we'll talk about that, and we're going to talk about the yoga teacher who is on trial now for murdering her love rival. And so that is happening, um, well, not as we speak, because I think they're a couple hours behind me in Central Time Zone, but it is happening this week. They started opening statements yesterday. So today would have been the first full day of testimony. So we're going to talk a little bit about that one. Um, So let's begin. I'm Tanya Hendricks, and I am an estate planning lawyer in Huntsville, Alabama. And why is an estate planning lawyer talking about criminal cases? Well, my background is in criminal law. I've been a prosecutor, defense attorney, and worked in divorce and custody cases. So I've had all types of trials in front of a jury, without a jury. So I know kind of the ins and outs of how jury trials work and sort of how the criminal system works. Notice I didn't say justice system. We have a legal system. We're a system of laws. Um, if you would ask most crime victims, they would say there really is no justice because, well, anyway, I won't get into that. But we are a legal system and not a justice system, and don't confuse the two. So let's jump right in. So there have been some legal maneuvers made by Alex Murdaugh's defensive team, and just to kind of backtrack a little bit. You probably know, unless you've been living under a rock, that Alex Murdaugh was guilty of murdering his wife and son. He has maintained his innocence throughout, and he's had the support of his surviving son. But he has maintained his innocence throughout the entire process. He's pled guilty to some other offenses that had to do with money and really kind of fraud type things. So he pled guilty to those things, but he has maintained his innocence as to these murders. Now, after the trial was over, the clerk of the court wrote a book or published a book where there's some allegations that some things that she said happened. And then the judge also began talking about the case. And even when the verdict was read, the judge commented on how all the evidence pointed to one outcome and they made that outcome. That's kind of a general statement, but the Murdaugh's defense attorneys have, rightfully so, said that and alleged that that's sort of showing sort of proof that the judge has a preconceived idea of Murdaugh and can't be fair and impartial. That kind of cloud his judgment. And so that's one of the things that they have said about the judge. But what Murdaugh's trial attorneys are doing now is what any good defense lawyer can do it with the ability to do it, and that is to make all the allegations they possibly can that it wasn't a fair trial, that he needs a new trial in order to get another trial, to get that conviction set aside. Because if you can get a conviction set aside and they have to retry a case, they have some advantages in a second trial because they already know what the prosecution's gonna what evidence they're gonna put forward. They're gonna know what the witnesses are gonna say. They got the transcripts from the first trial. So there are a lot of reasons why a second trial would be to their advantage. And it may also be that at a second trial, the state could decide they don't want to prosecute it again because it's an expensive trial. It took a long time. It took a lot of resources. So that the state could certainly say we don't want to do this again, or they could offer some really sweetheart deal to get him to plead guilty and just be done with it. So there are a lot of advantages to having a new trial. So and just the fact that maybe a second bite of the apple, he's found not guilty. Who knows? So what the defense attorneys are doing before the actual appeals are written and submitted to the appellate courts in South Carolina is saying we need a new trial because of these things. So one of the things that they have said is they need a new trial because the clerk influenced the jury. What they are alleging, and say what the defense attorneys and the defense is alleging, is that the clerk kind of interfered with the jurors. And when I say interfere, what their allegations are is that she asked them if they thought he was guilty, insinuated not to believe anything that Murdaugh or his defense team said, that insinuated they were liars, and that she rushed them to reach a verdict. Now, jurors are supposed to be off limits to everybody. I mean, there can be some interaction. There's going to be some interaction between the clerks, between the judge's staff, and jurors. That's natural because they're seeing each other every day, all day. What can't happen is for someone within the court system to talk to the jurors about their vote prior to the vote being taken. Can't talk to them about the witnesses, their guilt or the innocence of anybody. They can't do anything that remotely touches on what they are having to decide on at the trial. So for anyone, a clerk or anyone, to insinuate that someone is not being truthful, it's a big deal. It's a very big deal. So think about it. If you've never been a juror before, you are instructed to not talk to anybody about the case. And you can't even talk to the other jurors unless you're all in the room together or you're all talking together. You're not supposed to deliberate or talk about the case in just two or three of you in a group. You're supposed to all be together. And this you can't talk to the prosecutor, you can't talk to the defense attorney, you can't talk to the witnesses or the parties in the case. So who can you talk to when you're in the courtroom all day? You can talk to your fellow jurors, you can talk to the court staff. Just kind of, they're the only ones that can be friendly to you, really. They're the only ones that can say, hey, how are you doing? It nice weather, isn't it? I heard you got a kid. How's your kid doing at school? So the attorneys can't do that, but the judge's staff and the clerk staff can. And so there's a rapport that gets built between jurors and clerks and jurors and court staff. And so the jurors have this rapport with these people, with the clerk or the judge's staff. And if one of them insinuates that one of the parties is not entirely truthful or can't be trusted, then they're going to take that to heart because this juror has now built a relationship with this clerk, and it's someone that they can trust, that they view this clerk as a neutral party, not biased at all. That's the view. And so when it's somebody that they can kind of trust, and then they're put in a situation where they're having to judge whether this person testifying or this evidence put forth by this particular party, if that can be trusted, if they can believe what's being said, then they're going to fall back on the person that they do know and trust says, hey, don't trust these people. Then that's generally how a juror is going to think. They may not realize that's what's happening, but that's what happens. I mean, it's just nature. It's human nature that if someone that we have put kind of our or built a relationship with and kind of put our trust in, if they say, hey, this person is not really trustworthy, then what are you going to think? So that's kind of what the defense is alleging has happened here. That the clerk has interfered with the jurors and and insinuating, at a minimum, insinuating, if not outright saying that the defense can't be trusted. So that's one thing. And they're also alleging that there may have been some group text amongst the jurors. Now, that's not a problem if they're just saying, hey, you want to catch a ride together tomorrow? You want to go to lunch together tomorrow? What they can't have a group text about is, unless there was jury instructions. Now, there could have been some jury instructions that said, don't talk to one another. But generally, they're allowed to talk to one another. But if there's a group text that said, hey, do you think he's guilty? Did you believe this witness? Did you believe that evidence? What do you think about that? What do you think about that testimony? Those are kind of things they can't have a group text about. They can't talk about the case until they're put in the room together and told to talk about the case. So there are a lot of rules and restrictions on what jurors can and can't do. And if they have violated that, depending on the level of the violation, is kind of it depends is indicative of what's going to happen. If it is an egregious violation of juror conduct, then and it could rise to the level of there being some sort of unfair um, deliberations or something that could affect how they determine the case there and voted, then it could result in a case being overturned. And this is why, if you ever get called to jury duty, listen to the judge's instructions and follow those instructions. It will help so much. I hear so many people complain about the appellate system and how people that get convicted can take forever on appeal and the punishment won't ever be meted out like it should be because there are all these appeal processes. Well, sometimes there are really legitimate reasons to do these appeals and do new trials. If jurors mess up and don't follow the rules, that is a reason why some trials have to get redone. So if you're a juror, keep that in mind. Because if you're one of those who complain about all the appeals that people can get, remember that if you're on a jury, that you want to mind the rules because if you don't, it could end up in a conviction being overturned. I don't know this was going to happen here. We'll see what the evidence bears out if they're able to have a trial or have a hearing on the motion. Which gets me to the Murdaugh attorneys requested for the judge to be removed from the trial. So they have filed a petition or a motion with the Supreme Court of South Carolina saying, hey, we want this judge removed from this trial. They have not alleged that he cannot be fair and impartial. What they have alleged, and that's, so when you ask that a judge be removed from a case, you are walking a very thin line. Believe me, I've had to do that before. I've had to weigh the options of whether or not to do that with some other cases. But what it comes down to, especially when you're in a smaller area, the judges all know one another. So even if you get that judge removed, then you got the other judges going, well, why did this judge get removed? What's going on with these parties? And there may be some, I don't know, there's some concern on the part of attorneys that you may not be treated quite the same way, even by other judges. But particularly if you go in front of this judge with other cases, is this a judge who's going to hold a grudge against you and punish your future clients? So there are some very real concerns when it comes to asking for a judge to be removed from a case. And if he doesn't get removed, is he going to hold that against you in future hearings and rulings and things? So there are, and I'm not saying that judges actually do that. That's just the fear from lawyers. So lawyers just are concerned that can happen because judges are human too. And so we have that concern as lawyers that that's something that could happen with a judge. So Murdaugh's attorneys have walked this tightrope and said, not that the judge is going to be impartial or not be, is going to be partial, but that he may be a witness. So in their pleading, in their motion for a new trial based on what they allege is the clerk's misconduct, they're saying the judge may be a witness in that. And so if he is a witness, he can't oversee the trial. He can't oversee this hearing on the motion for new trial because he can't swear himself in and then turn around and go sit in the witness stand and after he testifies, go and sit back on the judge's bench. So that's where the defense attorneys are getting that he could be a witness, so he should not be the judge. And then they throw in there as well that, hey, he did make comments when the jury returned their verdict that seemed to indicate that he thought they made the right decision and that he believed that Murdaugh was guilty. And then the judge went on and made comments later about when he was talking to, I think it was his alma mater, he was talking about the trial and how Murdaugh certainly can't sleep at night or shouldn't be able to sleep at night for what he did. So defense attorneys are using those statements as kind of extra stuff to try to get the judge removed from this particular case from hearing the motion for new trial and also for any future hearings and decisions on this case. So we'll see what comes of all that, see what happens. I don't foresee this is going to end anytime soon because Murdaugh has time. He's just, and quite honestly, it's having been a criminal defense attorney and knowing what that's like for his attorneys, my guess is that they're probably getting letters and phone calls constantly from Mr. Murdaugh saying, "Have you thought about this? Have you done this?" Because all he's got is time. And there's prison libraries and there's access to legal books and other things. And so he is, and I mean, he's got time. That's all he's got is time. So he can write letters and suggest things to his lawyers, good or bad. But he can suggest those things to his lawyers, and they're probably getting an earful from him. And it may be good to them because it's less time they're spending on it if he's doing research and other things. So we'll see what happens. We are certainly not going to be finished talking about Murdaugh for a very long time, a very long time. Even if the trial doesn't get, his motions for new trial gets denied at this stage, we still have a long way to go before this is completely over and done with. So stay tuned for that one. And then I want to touch on this case, and it is out of Texas. This is the case where a woman by the name of Caitlin Armstrong has been charged with the murder of Mariah Wilson in Austin, Texas in May of 2022. This came to trial pretty quickly. I'm kind of shocked. In Alabama, they don't come to trial that quickly. She is accused of killing her love rival. So Caitlin Armstrong was dating a man by the name of Colin Strickland, and she found out that Miss Wilson was at least texting her boyfriend. She got very, very angry. And the allegation is that she shot her multiple times, with the last shot, according to the prosecutors in opening statements yesterday, the last shot, she stood over her and shot her through the heart. The prosecution said that there is some camera footage, there is some audio where you can hear Miss Wilson screaming for her life. And obviously they're going to be playing that at trial, so the jurors will hear that, and that we'll learn about that at the end of the day. So cameras are not allowed in the courtroom. They were allowed for the opening statements. They're going to be allowed for the closing arguments. But for the time in between, when testimony is being given, when evidence is being presented, cameras not going to be allowed in the courtroom. So we'll just have to get a play-by-play at the end of the day. from the reporters that were in the courtroom. But um, Miss Armstrong, what has made this case kind of interesting is one, she was a yoga teacher, um, and she was, you look at the pictures, she's attractive, and you would never look at her and go, she's a killer. Um, but it's very likely that she did. We'll see. That's what the allegation is. But then after this murder happened, she ran. She took off and she went to Costa Rica. Now, her attorneys claim she didn't know the FBI was looking for her. Yeah. So that's what they claimed. She didn't know the FBI was looking for her, but she ran off to, I think it was Costa Rica. She went, um, yeah, she went to Costa Rica. She had some plastic surgery done while she was there. She changed her hair color, but she didn't know she was being chased by the FBI, didn't know that anybody wanted to talk to her, yet she did all these things. So in a prosecution, what that is called evidence of guilt. I've asked so in a as a prosecutor before, when I was a prosecutor and we would have jury trials and somebody did something like that, like they took off running, they fled, we would ask the judge for a jury instruction on evidence of guilt. And um, the way they act in a way that they know they're guilty and it shows that they're guilty and they're trying to get away with it. So I imagine if Texas has that type of a jury charge, the prosecution is going to be asking for that jury charge because it obviously shows evidence of guilt on her part that she did those things. So this will be an interesting one to watch how it all plays out. Kind of I don't know, I guess I'm a little surprised it's going to trial, but, not really based on how she fled once, and then a couple weeks ago, jail staff was taking her to the doctor, and she took off running and tried to escape. So that's probably gonna be another charge that she's gonna have to deal with is an escape charge. It was really weird. There's video of her running in her prison stripe or jail stripes, trying to get away from the cops. So, um yeah, there is surveillance camera, with an audio that you can hear what happened. And so this case is happening again this week in Austin, Texas. I don't know how long it's going to last, but it looks like they have quite a few um, witnesses who will be testifying. I will like to see if Miss Armstrong herself will testify. That doesn't always work out so well with defendants. I think Alex Murdaugh figured that out. Sam Bankman-Fried figured that out. Probably wasn't the best idea to testify on them on behalves. I've had clients who did very successfully, um, but it doesn't always turn out so great for the client, for the defendant. So we'll see if she does, and then what she has to say as to what happened with Miss Wilson. But I'll say I'm shocked that this trial is already coming to trial. But I guess since she's in jail, so there is generally when you have when you have jury trials, so you have a docket, and a docket is a list of all the cases that will go to trial. The judge has to decide the order of case. So there are cases pending trial, at least here in Alabama, where I am in particular, that are 3, 4 years old and some older. And you ask, how can those cases still be pending? Well, you only have so many jury trials in a year, and you can only get through so many jury trials in a week. So normally what happens, at least, in my experience here in Alabama, is that we'll have criminal jury trials 1 week or 2 weeks, a month, or you may have, 2 judges having criminal jury trials and another 2 judges having civil jury trials, or 2 or more, however many judges you have. And so, and the reason they're limited is we have to pull in citizens to be part of these jury pools, to be picked to be on juries. So it's hard to do every single week. So you may have a couple of jury trials a month or a couple of jury weeks per month. And then you've got only so many cases that can be heard during that period of time. Now, I've had cases where times where I had 2 or 3 jury trials in 1 week, but they were short trials. But you get something like a murder case that's gonna take maybe a week. In Alabama, it doesn't take as long as it takes in some other places. It may take a week to 2 weeks, maybe 3 weeks here, in state cases. But still, that's eating up court time, is eating up, time for other people's cases. So it causes cases to get backlogged. And you add on top of that, when it's like a capital murder case, they're still waiting on forensics, they're still waiting on different evidence to come in, the defense has to do their investigation, so things get backed up and take a while. So the fact that this murder happened in May of 2022, and here it is November 2nd, 2023, and they've already started the trial, that's impressive. That's very impressive to go that quickly, but she's in jail. And so when a person is in jail, their case gets bumped up because they're a higher priority case. So even if there are some other people that have had pending cases for 2 or 3 years, if they're not sitting in jail, her case will get bumped up because she's sitting in jail. So that is something to take into account because there is a list of priority cases. At least in Alabama, under Alabama statute, there are priority cases. And so so when a judge is looking at his docket or her docket and saying, okay, I've got these cases ready for trial, who's in jail, how old the case is, what type of case is it? Is it a child sex offense, which those have priority? Those all kind of get bumped to the top. So child sex offenses, if they're in jail, the length of the case, those are things that the judge will look at to determine the trial order. And then other cases are going to get bumped because there's just not enough time in a week or 2 week jury term to hear everything. So that's why courts are so backlogged, and why you can't keep everybody sitting in jail, because if everybody was sitting in jail awaiting trial, it would just be it'd be chaos. It would be chaos. It would be a cluster. It would be bad. All right. So that is it for tonight. Thank you for joining me, and we will reconvene next week with a follow-up on what's happened with this yoga teacher case out of Texas, and if anything happens on the Murdaugh case. And then if anything else pops up between now and then, we will talk about that as well. Until then, y'all have a great weekend, and this YouTube video is in recess.